Hello, good evening.
Good
Oh,
evening, Gossip. We can hear you.
okay, thank you. Thank you so much. I had some issues with my Zoom coming in. Hello, mentees, good evening.
Good evening.
Okay, welcome to today's session. I think this should be your official or your pioneer session when it comes to JIIPCC for the patent drafting mentorship class. Welcome to today's session. My name is Gotslav Kamalani, and I'll be the moderator for today. It's such a pleasure having us in this session. Welcome, welcome, welcome. Here at JIIPCC, it's a major platform to learn, to know good things, and to grow. And I really, really pray that we would grow and would enlarge for sure. You're welcome. So there's one thing I'm really particular about a session I'm working with is the fact that every mentee must be involved. So we must be involved. Try as much as possible to have your camera on mostly throughout the session. This would help us a whole lot. So I really appreciate that. I see that we have our mentors already on ground. So kick or get the ball rolling and get this session on. Hello, Mr. Shama. I can see you already. Good evening, Nigerian time.
Yes, good evening.
Yes, welcome. Okay, mentees, do not forget the registration is still on for the JIIPCC first and second quarter for 2024 registrations. You can still reach out to friends, enemies too, colleagues to register for the program. We have amazing, amazing um, topics. You can see them on the screen already. These classes are amazing. So reach out to people, send out the flyer to register for this session. Okay, and ensure that as many who are yet to complete their payments or make payments for their certificates, kindly do that before the end of the program. Trust me, I have about 3 of these certificates to my name, and they are doing so well in my CV. And when the CV goes out, I think I get a lot of kudos for some of the things I've done through JIIPCC. So thank you one more time to JIIPCC. Now let's meet our mentors for today. It is patent drafting. Welcome to patent drafting for beginners. Okay, first off, I call her the IP goddess. The goddess of IP, it is Amusa Shukurat Modupeola. She's a proficient consultant, analyst, and educator in the field of intellectual property with public sector experience. She's a member of the World IP Organization, that's WIPO, World Intellectual Property Organization, committee and has a master's degree in intellectual property at African University Zimbabwe in conjunction with WIPO and the Japan government. She has been involved in professional training at the World Intellectual Property Organization as well as other IP-related bodies and has facilitated numerous intellectual property related programs, both online and offline. Mrs. Shukurat is the pioneer of an educational platform, DIN. It's on Instagram and it's mind blowing. That's the Intangible Nuggets, which facilitates IP awareness and brings the knowledge of intellectual property, that's IP, closer to everyone. Trust me, if you go on Instagram and you check her out on the Intangible Nuggets, you'll be blown away with the kind of knowledge you get from there. In celebration of the 2022 World IP Day, she partnered with other stakeholders to sponsor 5 IP enthusiasts and registered them for the WIPO advanced courses. Mrs. Amosa is an accredited agent of the Nigerian Intellectual Property Offices, that's the Nigeria Copyright Commission, Trademark, Patent and Design Registry, and her expertise are, but not limited to trademark, patent, industrial design, copyright, and trade secrets, respectively. A big welcome to you, Mrs. Amosa Shikurat Modupeola. It's such an honor having you with us. I believe she's already here, the IP goddess. You're very, very welcome. Okay, yeah, she's here already. Welcome, ma'am. It's an honor having you. Okay, our next mentor for today is the amazing Rakesh Sharma. Mr. Rakesh Sharma is having a thorough and multifaceted career spanning through a decade in patent analytics, drafting, and prosecution for US and EP jurisdictions. He works very closely with various engineering teams rather, and supported their portfolios from idea incubation to innovation management. Mr. Rakesh has excellent understanding of patent law, claim interpretation, and drafting skills. As a seasoned professional, he's readily engaged with various end-to-end IP services at different levels and provides intelligent IP solutions. He emphasizes more on promoting innovation for a better world. He loves drafting, patents, claims, keeping all the infringement perspectives in mind. Very, very important. Furthermore, he has a strong bent of mind towards IP automation and has sound knowledge of various IP tools and techniques that can be used for either improving quality of IP or increasing the overall productivity. He's also an excellent mentor and possesses all the leadership qualities required for a successful IP professional. Mr. Rakesh Sharma, welcome to today's session. So, ladies and gentlemen, please say a big welcome to our mentors for today. Mentees, at this point, I think you can unmute yourselves to say welcome to our mentors. Also, on the chat box, you can drop your welcome to our mentors. I think I only said the next few seconds. Let's know our mentees are here. Welcome to Mr. Rakesh. Welcome to Mrs. Amosa. Okay, we're going to go swiftly and quickly into today's session. I know we have our mentees for their presentation, so please get ready for that. But before we go into that, I think I'd love to do a quick introduction to the topics. So our mentors will take a few minutes to give a kind of introduction to today's topic, and then after the mentees give their presentation, we'll have you elaborately discuss the topic. So at least that way to help them to understand the topic based on what they've researched and more on what you're going to tell them after their presentation. So I think I would like to do, no offense, but let's say ladies first today's class. So Mrs. Samosa Shikran Modupeola, I'd love you to open up for us about patent drafting for beginners. Over to you, Mrs. Samosa.
Hi, God's love.
Hello, good evening, welcome.
Hi. Good evening, how you doing? Hi, Rakesh. How you doing? It's been a while. God's love, well done. I just knew when I heard your voice, I knew you were the one. You are the only person that can do this way. So let's just go into intro to patent drafting briefly. Let me share my screen so we can have everybody understand. Oh, sorry, I'm trying to see. Let me know when you can see my screen. Can you see my screen?
Okay, it's starting to share screen. Yes, your screen is up now.
Okay. So I understand that we have
visual.
I understand that we have different aspects of the JIIPCC training. So this one particularly is for intellectual property for inventors, but we also have the patent drafting aspect separately. But I'm going to borrow this slide just to put us through the intro to intellectual property when it comes to patents. So just as brand name and literary works are protected under the umbrella of trademark and copyright, new ideas that can be applied in useful ways can be considered inventions, and inventions regarded as patents. So as an inventor, you've probably come up with something inventive and you want to protect it. The best protection measure for you is patent. So like I said, just like you have brand names, when you come up with a unique brand name, what do? You trademark it. When you come up with a literary work that is original and fixed, what do? You find a way to protect it using copyright, although you have automatic protection on the copyright already, right? But you can go an extra mile just to like deposit your work with NCC to get that protection. And just like we have ideas which are inventive as well and new and useful, then you have patents to protect this kind of inventions. So that's just the introduction to this. So what are patents? We already know what intellectual property is about, right? It's just the creation of human mind protected from exploitation by third parties. I won't really go into this. What do you do to your IP? You create it, you protect it, you police, you enforce, and you monetize. So this is what it looks like. The first image is where you have this inventive idea in your head. You are trying to, put it in paper and see how you can come up with something useful. Then you are trying to protect it and you monetize it at the end of the day. So types of IP, we know that already. So we are going to talk about one type of IP today, which is trademark and patent actually. So patent research, what exactly is patent? Now, when it comes to intellectual property for inventors, you have this kind of ideas, this kind of protection, either patents, plant variety or industrial design. But I want us to take note that patents, plant variety, and industrial design are not types of patents. Because I know I've seen some people classify types of patents, and you have patents, plant variety, and industrial design, right? But considering the fact that yes, patent and industrial design are under the same registry, plant variety is not a type of patent, because when you go through the Patent and Design Act, you realize that under the non-patentable subject matter, you have plants and animal, right? So because plant and animal cannot be patented, we don't classify them as patents. So we have a different department, a different body entirely, which is responsible for the plant variety. So plant variety is not really a type of patent, but it's not a type of, because under the patent, like I said, plants and animals are not covered in our Patent and Design Act. But in other jurisdictions, some people are able to patent plants and animals. So you have to look at the law of your own jurisdiction to determine which kind of protection you are going to go for. So let's look at patent, definition of patent, criteria of patentability, and so on. So what is patent? Patent is an exclusive right granted for an invention, which could be a product, process, or equipment that provides a new way of doing something or provides solution to a technical problem. This definition is everywhere. You find this definition everywhere. So I'm going to give you a different definition. So I say that patent is like a trade by barter between the government and an inventor. And from the image, you can see there's an exchange of idea and handshake, right? So this patent is going to grant the inventor an exclusive period of 20 years so that you can use it the way you like. And in return, the inventor discloses his or her invention in details in such a way that the invention can be recreated by anyone when it enters the public domain. So what this means is that you go to the government and say, oh, look, government, I have something new and inventive that can benefit the society. And I want you to give me 20 years protection period to protect and utilize this thing. Give me that exclusive right. And the government say, okay, fine, that's fine, but you are going to do something for us in return. You are going to give us the disclosure. You're going to disclose everything about this invention to us so that when your invention expires and goes to the public domain, somebody else can pick it up, develop more on that idea, and probably come up with something new or an upgrade to that particular thing. And that way is able to benefit the society as well. So that's what patent is basically. But before you can actually get a patent for something, it has to meet up with these three criteria, which is number one, novelty, number two, inventiveness, and number three, industrial applicability. Now, when I say novelty means something new, something novel. Now, it might not be entirely new. The fact that it's new doesn't mean that something that is not existing at all. It could be an upgrade or an upgrade of what has been on ground before. As simple as maybe you find a way to put straw in water, as long as you're solving a particular problem, but make sure that your invention is inventive and is industrially applicable. Now, inventiveness in the sense that when I put A and B together, I'm not going to arrive at C. It shouldn't be that obvious. Like somebody in that field should not pick up a patent application and look at it and say, I can do this. It shouldn't be that easy, right? Then industrial applicability means that it has to be something that is usefulness. So when you check some other jurisdiction, they use this is that inventiveness or non-obviousness. It's either novelty or new. The industrial applicability, sometimes they call it useful or utility. So you have to look at the jurisdiction you are in to understand the terms you are actually using. Then we'll talk about, sorry. Can you still see my screen? I think I'm lost.
Yes, please. Yes,
It's
please.
visible.
Okay, now, so what can be patented? In the definition I gave earlier, I said it could be a product, a process, or an equipment. So look at what we have here. An example here, a product like your mobile phone is a product. Know-how, like the process of doing something is it can be protected. Then this is that maybe an equipment like your television is not a product, but maybe your machines and so on and so forth. Those are equipment. All of this can be patented. Now the question is, what cannot be patented? Okay. Oh, sorry, I don't have that here. So when it comes to what you cannot patent, things like ideas, plant and animals, abstract ideas, mathematical expression, all of these things cannot be patented. So when you are trying to get a patent for something, number one, you have to make sure that what you are doing has a patentable subject matter. Patentable subject matter, that is not something that exists in nature. For example, you can't say you want to get a patent for oxygen. Oxygen is not patentable. So your patent application has to have a topic that has a patentable subject matter. Then it has to be novel, it has to be inventive, and it has to be industrially applicable. Now, let's now assume you fulfilled all of these criteria. Then you want to now proceed to now file a patent application. The first thing you need to do is you have to carry out a patent search. Patent search is very important when it comes to you doing something on patent. Can you still see my slide, Godswill? Please confirm.
Yes, please. Yes, please.
Has it changed?
Yeah,
Can you see a patentable subject matter?
Yes, please.
Okay, that's fine. Okay. So it has to be novel, inventive, and industrially applicable, like I said. So I think I'm going to stop here because it's just intro. So Rakesh can also give his intro, then we listen to the mentees.
Okay, thank you so much for a fabulous start to an amazing quarter. Thank you. There's one thing I'm taking home already. Mentees, I hope you heard that where she gave us a new take on that definition. Patent being a trade by barter between the government and the inventor, giving the inventor 20 years. That makes so much sense. One thing about JIIPCC is you get mentors who break it down to the barest minimum. Thank you so much, Mr. Musa. Okay, over now to you, Mr. Rakesh. Let's have your introduction on the topic.
So, first of all, I would like to thank Amusa for giving us this much details and very wonderful interpretation of the patents. So I'm sharing my screen. Just let me know once it is up.
Okay, yes, it's up now.
So like Amusa has already mentioned about the patents and all the details. So in our today's session, we are emphasizing or focusing more on the patent drafting. So before jumping on to the drafting, this is the overview which we are going to discuss in our today's session. Like the first one only we are talking about necessity of patents, like what Amusa has mentioned, and what is the process of patents, or especially what is the patent drafting, and it will be followed by a very easy assignment for all the attendees if you want to attend. So this is what we are going to discuss today itself. And before jumping into this details, the overview, if somebody want to ask, So this is a WIPO drafting manual. It is having all the details about the patent application, why these patents are necessary, and the definition of patents. So I would like to seek the reference of this WIPO drafting manual, because it is having very good examples as well as the professional tips. So from here, the first two modules are related to only the patent basics, but from this itself, it is associated with our today's topic of discussion, which we are going to discuss it in detail, like the what are the different parts of a patent application and how we should write it, what is description, claims, drawings, and abstract, what is its format, then what are the types of claims, like uh, Amosa has mentioned very good examples, like if somebody want to claim for oxygen, then it is not allowed. But if somebody has invented some new kind of method by or some chemical reaction, by using that chemical reaction somebody is able to produce oxygen out of some other chemical reactions, then for that method of producing the oxygen you can get a patent. For the same example she has mentioned about the mobile phone, so you all might be surprised to know that there are more than 2 lakh patents in one single mobile phone you are carrying with you. So it is a bundle of n number of different patents you are holding in your palm, and you are having it in your pocket. So these are all the value of patents or the power of patents companies are relying on. So it is the intangible property which helps the companies to grow and flourish, and it is giving us giving the direction to the research and development, and indirectly for the society to proceed in the direction of upliftment and betterment. So now talking about the only the patents, Amosa has already provided a very good and basic information about the criteria, that it should be novel, it should be inventive and industrial applicable. So in our session, we will be discussing about that if you have identified something, if it is novel, like it is not being disclosed by anyone, then how we should capture those novel aspects. We should write it on paper to reflect what actually it is. So we are going to discuss about writing the patent application and how it is different from normal writing or normal technical writing or writing a research paper. How these patent writing, we call it patent drafting, is different from the normal technical writing. This is we are going to discuss in our today's session. So this is the basic introduction from my side.
Okay, sorry, I was still muted. Okay, Mr. Rakesh, thank you very much for that amazing introduction. That means today's class is already loaded and it's just week one. Thank you so much. Thank you. Thank you, really. Okay, so we're going to another fun part of our session today. Let's hear from our mentees. Here at Gypsy, there's no lazing around. It's week one, but they are ready for a presentation. Okay, so I want to give the floor over to the presenter for today's session. Hello, presenting mentee. Good evening. Who's presenting today? Hello, mentees. Who's our presenter for today, please?
Shall I start with if Amosa is on mute actually?
Yes.
I think you're waiting
Okay,
for
go
the
ahead, ma'am.
presenters, right?
Yes, among the mentees, one of them is meant to present. So
Okay.
we're looking forward to the presentation.
I think it's just one presentation because I got just one.
Yes.
Yes.
Okay.
Okay, is there a backup presenter, please?
I can present my slides.
There's a backup presenter. I'm present.
Okay, okay. That is, please tell me if I got that correctly. Is that niggas? Did I pronounce it correctly, please?
No, you pronounce it as Nugus.
Okay, niggas. Okay, thank you. Please guys with the presentation. Thank you very much for stepping up.
Okay. Do you know how I can share my PowerPoint?
Okay, on your screen, you should see three buttons that shows up for share screen, or if you see a button that says share.
Yes, there is one.
Okay, so click on share and then you see various ways to share and click on share screen.
Okay.
Mr. Dennis, are you here? If you have the slide, if you could also help them share the screen to help us as well.
Okay, let me try and see if I can access the slide and share.
Thank you very much. Thank you. But Mr. Nichols, I think you can now just kick off with the presentation. It's no problem. Okay, I think someone is sharing a screen. Hello, Nichols.
Yeah. Shall I begin?
Yes, please, you may begin. Thank you.
Okay. I think somebody has shared his screen. If you can open the patent.
Yes, I think the person is trying to open up the document.
If you can't find it, let me just share for you, okay?
I think someone is already sharing a screen.
But we don't have the document yet.
The one that says patent, open it.
Nicholas, but if it's open on your end, you could carry on. I think once the screen come up, you just continue with the screen.
Okay.
Yes, please. Thank you. To help us save a lot of time. Thank you.
Okay. Our topic is under the... Can you hear me?
Yes, please, loud and clear.
Our topic is patent drafting essentials, understanding subject matter and the significance of patents. Under this topic, I'll try to cover the definition of patent drafting and the cases of Ethiopia and Nigeria in patent drafting. And also I'll try to describe about types of patents, what can be patented and not patented, and the benefits of patenting, along with the type of patents. First, I begin with the definition of patent, what a patent means. Well, patent is an exclusive right. Patent is an exclusive right, and it's granted for an invention. It's not for any other thing, but only for an invention. And invention is a product or a process that provides, in general, a new way of doing something. For example, if there was a way of, yes, thank you. This is the one. The second slide, please. The second one. Yes, thank you. So invention is a new way of doing something. For something to be called an invention, there has to be a different way or a different process that we could do it. For example, if we produce a material through one process, but if we discover another way of producing the same material, then I think we can call that invention because it's a new way of doing something. And patent drafting, patent, it's an exclusive right. Like we have different rights like human rights and democracy rights, but patent is a right by itself. It's an exclusive right. It's not an ordinary right like any other rights, but it's an exclusive right. But patent drafting is a process of writing the patent description and claims. Patent drafting is a process, while patent is a right. When we understand the subject matter, in the case of Nigeria, there is an article, section 1 of the Nigerian Patents and Design Act, laws of the Federation of Nigeria 2004. I'm not familiar with this one, but when I go to our case, there are 5 different steps we use in Ethiopia for patent drafting. The first one is filing an application. When we file an application, the applicant must submit a patent application to the competent authority in Ethiopia. There is one authority that is used to give such type of rights. It's an authority. And second, when that application is given to the authority, it examines that application, and based on that application, if the patent, if that thing is if that thing is a new way of doing something, if it's a process that was not used before, after a due examination, the authority will accept it, and after accepting that, it will be published on a national gazette. It's some sort of magazine, a legal magazine, and on that magazine, it says this type of patent is protected under our authority, and it cannot be used by any other else. It says that for literature works in our country, it's for 50 years. After 50 years, the right extinguishes. The next one, please. Patentable subject matter. I'll pass that one because it's what I explained in the definition. It's about new products. Patent is all about new products. And yeah, so let's move on to type of patents. Yeah, we said there are 3 types of patents: design, utility, and plant patent. But as has been said earlier, it was said that there was no type of plant patent, so I'll try to pass that. I'll just say there are 2 types of patents: design and utility, if I'm not wrong. And let's move on to the next one: what can be patented and not patented. What can be patented is things like chemical compounds, computer hardware, machines, drugs, Netflix, iPhone, 3D printer, helicopter, drone. These things are, most of them are scientific inventions. And what cannot be patented are, for example, aesthetic creations. Aesthetic creations are things that are natural, and those things that are natural, that exist naturally by themselves, they cannot be patented. And also programs for computers or presentations of information, methods for surgical or therapeutic treatment or diagnostic methods. Such kind of things are very important for our survival. So making them patented will be more of disadvantages than advantages. So they are not patented. And also literary or art.
Hello, Nichols.
Artistic works.
Okay, so I think he has an issue with his network. Is he back now? Please, can you all hear me?
Yes, I can hear you.
Okay, we lost you for a bit there.
Slide number 8.
Okay, I just need to pick up the pace to take time for the presentation. Thank you.
So I'll move to the patentable products. As I have said earlier, aesthetic creations like plants, animal varieties, biological processes, anything that is natural is not patented. Let's move to the next slide. Slide number 9. The next topic is benefits of registering a patent. The first one is alienation right. By alienation right, we mean that if I have a patent right on something specific.
Sorry, Mr. Negos. Sorry for cutting you short. I don't know.
Okay.
Do you mind speaking up a little bit more? Am I the only one expressing this issue? Can you all hear him clearly, please?
No, we can barely hear him.
Yes, we can.
Okay, thank you. Mr. Negos, do you mind just opening up your voice a little bit more? Thank you. You're doing a great presentation, so we want to enjoy more by hearing more of what you're saying. Thank you.
One of the benefits of registering a patent is the first one is alienation right. By alienation right, for example, if I have a patent right on something specific, any other person cannot use that type of that process of producing a thing because other people are alienated from that. That's one of the benefits. The second one is legal action. For example, if someone produces that same thing by using my process, I can raise a legal action against him because that's the real definition of right. To use it against other people who violate it. That's the legal action. The other one is right to relief. I believe it's related to legal action and licensing benefit also is one of the benefits. Let's move to slide number 3. Slide number 3. Yes, slide number 10 is about patent drafting. Anatomy of a patent application. I think I have discussed it earlier about how the process we use. First there is application, then there is examination, then license will be given. So I think I'll pass this part for the sake of consuming time. Patent drafting best practices. The first one is as a process. Okay. Okay. I will finish my. I'll try to finish my presentation. So, can you move to the last slide, please? So these are our examples. We had 3 examples of patent draft illustration, and yes, I can from the 3 I can discuss one for the sake of time. So one of the examples was patent draft illustration was herbicidal composition for control liquids. And there are processes, for example, one of them is object of the invention. Object of the invention means, as per our example, the main object of the present invention is to provide a broad spectrum synergetic herbicidal formulation comprising the first active ingredient, which is quizalofop, the second active ingredient, which is formisan, and the third, which is the mazitapir. Overall, we had 3 examples of patent draft illustration, and I think I'll stop discussing about them for the sake of time. To slide number 16. The importance of patent drafting is similar with the benefits. The first one is to drive innovation, because if people invent a new thing and if it's used by anybody else, innovation will not be driven. So one of the purposes to drive innovation is one of the importance of patent drafting. There are 5 other importances of patent drafting. If you can see them, one of them is to create legal boundaries. To create legal boundaries means to create a legal sanction where I can only use my patent secrets. I can only use my patent, right? And any other person cannot use them. And also increase the competitive value of patent, easier enforcement, and inhibits invalidations. Let's move to slide number 17 and I'll finish. It's our conclusion.
Hello, Nugus. Please, we can't really hear you at all. Please, can you speak out loud, or can you turn up your voice so that we can hear you?
Okay, can you hear me now? Can you hear me?
Yeah, it's a bit better, but we'd like for you to be more audible. Thank you.
Okay. Now this is my conclusion. Mastering the art of patent drafting is essential for securing intellectual property rights, which is one of the rights in property law. Understanding subject matter and the significance of patent empowers innovators to protect their valuable creations and drive economic growth. And I would like to thank on behalf of our group, including Nana Kojo, E.G. Esther, Zinatu Ahmed, Minugus, Favor, and Chigozirim. And I finish my presentation now.
Okay, Nigus, thank you. I'm sure that was a great presentation, but I know over time we're struggling to hear what you were saying, but good one. Thank you for doing a great job as a backup presenter. Also, thank you so much to Mr. Mosa for sharing the slides. Thank you so much. Really appreciate that. It means a whole lot to us having a mentor do that for us. Okay, quick question before our mentors take over. Nigus, please, what country are you speaking from? Hello, I didn't get that, please. Oh no. Okay, I can barely hear what you're saying. Probably you could type in the chat box. That'll be fine. Oh, I was asking again because I noticed that I heard so much about Nigeria. I was really hoping to hear what your own country says about patents. It has been so mind blowing for me. Because here at JIIPCC, we're global. It's not just Nigeria. So, mentees, please get this nugget. Here at JIIPCC, when you're bringing the laws, get us laws from several African countries, several countries around the world, not just Nigeria. We have different mentees from different parts of the world. Thank you very much. Okay, so I'll move over now to our mentors to hear their take on the presentation on the slides that the slide has been submitted before now, and to give us further and better affidavits on the topic for today. As usual, I will start with Mr. Samosa, please. Thank you.
Thank you, Godswill. Thank you for the presentation, Nicholas. Just that we couldn't hear you clearly. I had to use an headset because I really couldn't pick what you were saying. But rather than that, I think you did a good presentation. And I would also have liked you to mention your country and also tell us the provision in your country, because I understand that you're not from Nigeria. However, I don't know if in your country you consider plant and animal as patentable subject matter. So I realized that when you were talking about the plant patent, you skipped it because I mentioned that plants, we really don't classify plant patent as a type of patent in Nigeria. So it would have been nice if you have told us how it works in your country. For example, in the US, they can patent plants and animal. So plant patent is a type of patent under their own jurisdiction. So it would have been nice if we know what what's your country, which country you're from, and what applies or what's applicable in your own country. So that's a good one. And I also feel like this today's presentation is basically about introduction of patent drafting. So I expected to see more of introduction of patent, give us relatable examples. The examples you gave were examples that were, technical. You could have given us an example like the big biro. That's a very basic example. You understand? Then I thought you would have given us more explanation on the criteria for patentability. For example, novel. When you say something is novel, under what circumstance can something be novel? If you say something is inventive, give us examples like, okay, if I have a pen that has a cover and eraser, and I have another pen that has a cover without eraser, how can I determine novelty in that instance? How do I know if it's inventive? So you put two similar objects together and tell us, okay, why this is novel and why this is not novel. Why do you think this is inventive, or this might pass the inventive step, And why do you think this might not pass the inventive step? Because we are still in the basic introduction. Because if you are not able to understand the basics, when we get to patent information, patent search, drafting of patent, drafting of claim, it might be hard to understand because you don't understand the basic. Okay, so I think then under the patentable subject matter, you were supposed to list those things that can be patented, but instead you have utility, you had the criteria of patentability under the patentable subject matter, which is not supposed to be so. So I think those are just the corrections I noticed. And yeah, I think that's it. So I'm just going to give us, I'm going to put up my slide just to give us a simple explanation on novelty and how you understand novelty and inventiveness, just to see the differences. And let me know once you can see my slide also.
Okay, it's up now.
Okay, so I wanted us to give reasonable, understandable, simple examples so we can all understand. So back in those days, when our parents also write love letters, right? They have to like come up with maybe dipping ink, feathers in ink just to write these letters, and they have to travel with it. But at the end of the day, you realize that why using this ink, dipping the feather in the ink to write, one way or the other, it smells. When they put it in their pocket, everything rub off together and you can't even read what exactly has been written. Now, that is a problem. So when you are looking at patents, there has to be a solution to a problem. If there is no problem, then why do you want to invent to solve that problem, right? So you have to look out for a problem first. Now, your patent is supposed to solve that particular problem. So the problem in this ink and feather thing is that, number one, it smells. You can't carry it about. You put it in your pocket or in your bag, it can pour away, right? And someone was like, okay, fine. How do I solve this problem? Whereby I can have something that I can, so a writing material that I can carry about, I can put in my bag, it's not going to pour away. And they came up with an idea of putting this same ink in probably a tube and finding a case to put it and a tip for it to write. And that's how they came up with a ballpoint pen. Right? So the name BIC is actually the trademark. That's the trade name for selling that product. There are two brothers, BIC and Biro. They come up with this invention and they name their product BIC Biro. So that BIC, the name, is actually the trademark for that invention. So when you've now come up with an invention, yes, you've cited a problem and you've come up with an invention, what do? You try as much as possible to get a patent application. So we've done this already. So invention is defined as a new and inventive solution to a technical problem. Now you can see that new, inventive, and technical problem are highlighted because it involves a substantial amount of human ingenuity, creativity, and inventiveness. So merely finding something already existing in nature cannot qualify as an invention, right? So what is patent? We've talked about this. Exclusive rights granted for either a product, a process, or an equipment that provides a new way of doing something or serves as an improvement to an already existing invention. So that is what patent is basically. And I talk about the trade by barter just for a better understanding for you. Then also, patent is characterized as a negative right in some instance because if you, for example, now there's this big Biro, the big Biro, you want to work on that big Biro, you want to upgrade what has been on ground before, you are going to need the old patent. So if that patent application is still in force, it means you won't be able to manufacture your patent without a permission from the owner of the initial patent on Biro, right? So it's majorly a negative right because it doesn't really give you the right to manufacture, especially when you are upgrading on something that's already in the market. But if you're coming up with something disruptive for the first time, then fine, you are the owner of all the patents in that aspect. So in other words, patent confers a time-limited, government-approved monopoly for the invention set forth in the patent claim. So when we are talking about patent claim, we'll talk more on what patent claim is. So this monopoly gives the owner of the right, one, the right to control who makes, use, sells, offer for sale, or import the patented invention. And I'll give you a very good example here. I don't know if you came across the issue between Apple and what's this people's name? Massimo, yes, Massimo and Apple. They had a fallout recently. So Massimo is like a health technology company that produces patent or that invents patents on health, right? And you realize that Apple Watches these days, they have patents in them whereby it can help you to track your health, blood oxygen, and so on and so forth. Meanwhile, Massimo have a patent on blood oxygen, but Apple went ahead to still do the same, to still work on this same invention without getting any permission from Massimo. And what happened? Massimo sued Apple. And what did the court say? Because Massimo is in the US. Now, intellectual property is territorial in nature. You are only protected in the country your patent is registered in. So Massimo's patent is registered in the US. So what the court says was that it banned Apple from importing this same watches with the blood oxygen feature into the US because there's already a patented invention in that jurisdiction. However, this doesn't stop Apple from importing from other countries wherein that patent is not patented. So I'm just trying to explain the point of import and export of patented invention. So you also have the opportunity or the advantage to receive damages for infringement, and you can also seek injunction against further infringement. So now, determine patentability. We've talked about the patentable subject matter. So why are we mentioning patentable subject matter? Because if, let's say, for example, you want to patent your patentable subject, the topic of your patent is a method of trapping oxygen in the air. That kind of patent application is not going to work. Because if you trap oxygen in the air, do you want to kill people? Now, in some jurisdiction, that kind of invention might be patented. However, when it comes to commercialization, you won't be able to commercialize that kind of invention because you have to look at the idea of public morality. Is it good for that environment? So any useful product, process, method, machine, equipment, manufacture, composition of matter can be patented. So if your patent application falls under this highlighted list, then it can be patented. However, if the topic of the application falls under what you have as non-patentable subject matter, then it's not going to be patented. So if you bring a patent application for maybe plant and animal in Nigeria, it won't be patented because under our patent law, plant and animal are not something that can be patented. But in the US, I think they accept patent applications for plant and animal. So you have to look at the jurisdiction you are in. And I also like Rakesh to talk about if they do plant and animal patent protection in India as well. So criteria for patentability, we've talked about patentable subject matter, novelty, inventiveness, and industrial applicability. So this is what I want us to look at. So novelty as a criteria for patentability generally requires that the claimed invention must not be made available to the public prior to filing date of the invention. And yesterday I came across something on Instagram that the EU rejected Puma's design application for a particular shoe design. Why? Because Rihanna sometimes ago posted that particular shoe on Instagram. So even social media contribute to prior acts. So as long as you've made it available to the public, then you risk non-grants of a patent application or even design application. So in a claimed invention is not novel if all of its elements or features are found in a single prior act reference. So prior act is what has been on ground before, what has been in the body of knowledge. So you have to make sure that what you are doing is not something that is already existing. And if it's already existing, how are you improving what has been on ground before? So an exception to this novelty is grace period. And in some countries, the grace period is 6 months. Some countries, the grace period is 12 months. So if after or within 6 months, if you disclose your invention 6 months, if you disclose your invention, you can still apply for patent application 6 months from that time. But for countries that don't have grace period, it means once you've disclosed, you've disclosed. So it's not advisable that you always disclose, because if your country doesn't have this grace period exception, then there's nothing you are going to do. So try as much as possible before you disclose an application. And this applies to researchers majorly, because most researchers want to publish. They want to publish in journals so they can get their promotion, right? But what we advise is try and file a patent application. So while the application is in process, then fine, you can now go ahead to publish your journal or your publication. So this is an example of novelty. So a prior act reference discloses a chair with a seat and 4 legs, which may be made of wood or metal. Now, notice this. You see a prior act of a chair, you see an invention X, and you see invention Y. You realize that inventor X invents a rocking chair made of wood with a seat and 4 legs, but only laid claim to a seat and 4 legs, but no mention of the rocker attached to the chair. So when you see this prior act, you see that the prior act is a seat, 4 legs with backrest, and so on and so forth. Now look at invention X. Invention X is similar to what we have in the prior act. The only difference is the rocker, right? So is invention X in its claimed only a seat and 4 legs? In this case, this invention will not be considered novel because it has the same elements that this prior act has. However, if he had mentioned rocker in his claim, then this rocker is likely to make his this application patent novel, because the prior act does not have a rocker. Now let's look at invention Y. This invention Y has 2 seats, it has 2 legs rather. It has a rocker but has 2 legs. In this case, invention Y is novel because the prior act and the invention X has 4 legs, but invention Y has 2 legs and also has a rocker. So you have to be very you have to pay attention whenever you're drafting your patent application with respect to novelty. Then when it comes to inventiveness or non-obviousness, it requires that the claimed invention must not have been obvious to a person skilled in the act. That is, if any average person, if a person of average skill in that field of invention put together what you have done, they should not be able to get to your answer, arrive at your answer immediately. So let's see an example of inventive step. So prior act discloses a chair with a cup holder to hold coffee cup. So inventor A invents chair with a holder to hold bottled water. What is the difference between cup holder to hold coffee cup and the one to hold bottled water? They are in the same class. I can decide to use my chair holder for coffee cup to hold bottled water. So in that kind of aspect, this invention lack inventiveness, because inventor A patent claim will likely lack inventive step in the view of this prior act, because an ordinary chair designer will likely be motivated to make a chair with a bottled water holder in light of this prior act. So this prior act that says a chair to hold coffee cup can also hold bottled water. So if I invent something that is holding bottled water, when the prior act can also do that, it won't be considered inventive. And this is an example. So you have a pencil and eraser. And from what you have here, it looks like a pencil and the kind of sellotape eraser around it. Then you see the next one, a pencil and eraser, but somehow they found a way to put that eraser in that pencil. Now, to somebody, if I'm not in this field, to me, it might be non-obvious and inventive. But to somebody in this field, it might be something obvious, right? So you have to make sure that your patent application has that novelty, inventiveness, and industrially applicable. That is required. It's something that is useful and you can mass produce it, basically. So I think I'm going to stop there and let Rakesh take over. Thank you.
Thank you so much. Thank you so much. Wow. Wow. Okay. That was amazing. Thank you. Rihanna, good job. Thank you so much. Thank you so much. What I think of what Rihanna has done to Puma, it breaks my heart. Okay, thank you so much, Mr. Musa, for lightning one. Thank you so much. Okay, Mr. Rakesh, over to you. And I'm also looking forward to hearing what is the law saying in India regarding patents and especially plant varieties. Over to you, sir.
So first of all, I would like to thank you, Nigos, and my heartfelt thanks to Amosa for giving us so much wonderful presentation and very relatable examples for patents. And thank you once again. So now I would like to start with where Nikos has mentioned. So first of all, I want to give some feedback on his presentation. Actually, in his one of slide number 16, he has mentioned about to stop infringement. So everybody has given today the definition of patents that even Nigos, Amosa, and me has mentioned. The definition of patent itself includes the exclusive rights. So patents are always giving us the rights to exclude others. And in his slides number 16, Nigos, you can check that you have mentioned about that it will help us in advantages of patents are to stop infringement, but actually the overall objective of having the patents is to have more infringement, then only we can have more royalty. So this is the perspective we must have to change, because patents we are having to generate more revenue, to protect our invention, that is fine, but to exclude others who are like making, using, selling, or importing our inventions without our own consent, or without taking permission, or without giving us the royalty. So this is the overall objective of patents, is to generate the revenue itself. So we should not think of uh, stopping the infringement, but now from there only I am going to start. So whenever we are trying to have a patent, so objective should be having a balance between the scope of patent should be to avoid the prior art and to have more and more infringement perspective. So it is a balance between these two. Whenever you are having any idea, it should be narrow enough so that there should be no prior art, but it should be broad enough, there should be infringement. So always keep that perspective in mind whenever you are going before a patent. Clear? Am I audible?
Yes, please, you are. Yes, very clear. Mentees, please, I
Okay.
hope you took note of what he just said. Please carry on, sir.
Okay, so I would like to start with one example first. Wait. Then we can jump into the more details that what do's and don't we have to follow. So this is one very good example we usually give. So like Omosa has mentioned about the novel and inventive aspects, we must have to identify what are the novel features and how we should write it, but how we should differentiate. Like she has given very good examples of cup and pencil with eraser. In the similar way, I am giving you a very basic and easy to understand example. Like some client or some engineer has invented an apparatus, and that apparatus is for turning lead into gold. Lead is one kind of metal. It is an apparatus where somebody, if it is putting lead, it will turn it into gold. So for that apparatus, it is having a box like metal frame. Let me use this draw feature to give you a quick understanding. So now you have these things: apparatus which is having a box like metal frame, a motor, a bowl where you will put some kind of this lead as a raw material, and then
Sorry, Rakesh, are you sharing your slide? Because we can't see.
oh, sorry.
Yeah.
Let me just share. I was having a feeling that I had already shared.
Oh, okay. No, you hadn't.
Okay. So
Okay,
just let me
it's up
know
now.
once it is.
Thank you, Mr. Musa, for that.
Thanks for letting me know. One example I would like to start with. So it is an apparatus which is having the ability of turning lead into gold. So this is the overall novel aspect of this invention, and it is an apparatus turning lead into gold. So this apparatus has different parts, like it is having a box-like metal frame and motor, a bowl, and a retaining scrap lead. And this is the most critical part of the invention, which is lead gold zapper element, which is helping in metal transition. Metal transition means to turn lead into gold. So there are, if you have to count it, like there could be 1, 2, 3, 4 and 5 elements are there. And by having these 5 elements, if you have to write down a claim for patent application, so it will look like this: an apparatus for turning lead into gold. It is having metal box like frame, motor, bowl, lead gold zapper element. So now by writing it in that way, you can write n number of possible claims out of these elements only, which I just want to highlight by quickly giving you an overview. In details, you can read through this drafting manual. So now if you pay a close attention here, what we had mentioned, a box like metal frame, then we are providing the relative arrangement of different elements, how these are connected and interconnected to each other. So there are 2 or 3 things we just need to pay attention. So if we are writing about apparatus, so apparatus is like having multiple components, and we must have to define their relative arrangement with each other. Suppose iPhone and Android phone both are having screen, processor, memory, but architecture is different, and this is the only reason they have got the patents differently. So in the same way, like if elements are same but their relative arrangement is different, then only somebody can get patent based on that only, not on only the separate components, and we are not defining their relative arrangement. So now here if you can see box like metal frame, then electric motor where it is mounted on that box like metal frame, we have mentioned it here. Then a bowl, where that bowl is situated in this apparatus, we have mentioned here. Then a lead gold zapper element, where it is attached, we are presenting its relative arrangement. And if it is apparatus, we are simply providing the relative arrangement of each and every, like the configuration of each and every component. So for apparatus, the configuration is more important than the function. But if we are trying to patent a method, then function is more important than the relative configuration. So always keep that thing in your mind. The second thing is both Nigus and Amosa has emphasized that it should be clear. So while writing the patents or while writing the claims, it should be clear, concise, and should convey only clear meaning to the readers. So in this particular claim, if you can see, if we have to rewrite these claims differently, so what we can do, we can jump onto the same by writing it in this way. So it is also having 3 elements. We have removed one extra element from here. If you can check, I had removed a bowl for retaining scrap element here, just by a bowl for retaining this. So by removing the extra limitations, we can write it in that way: electric motor, bowl. But now also the scope, we can say it is very narrow. Why? Because somebody, rather than using electric motor, if somebody is using some other means, so they can easily design around this patent. Or for bowl, if somebody is using some other container which is different from bowl, and no need of specifying the function itself, this is unnecessary. Electric motor is itself, we have to rewrite in some broader manner. This is the main novel part, so we need to capture this very beautifully, but these are all the supportive elements. We can think of some different writing style to write it in such a manner that these should be broader and should not be captured by uh, any other infringer or any other design around possibilities. We should not give it to any other competitor. So by simply writing electric motor, we can write it as a power source. So now if you can see, this is the third possibility we are coming up with. So now electric motor has been replaced by a power source. Bowl for retaining scrap is still there, but a lead gold zapper element, we are not changing it at all, because this is the key aspect, we can say the linchpin or the most critical part where novelty of that invention lies. And how we are just rephrasing or rewriting the main idea to get the patent, to keep the scope broader, to make the information or the meaning very clear and concise. This is what we call patent writing. And by rewriting again it fourth time, we can simply say motor we have replaced with the power source, lead retainer. So see, bowl we have simply replaced it with retainer. Retainer could be anything. It could be a bowl, a bucket, a glass, anything we can use. Retainer is a much broader term. So this is, and here instead of writing the motor, we are writing power source. Power source could be anything, be it the electric motor, solar powered, any other means, we are covering it here. But lead gold zapper element is same, because we are not changing the novelty of that invention. If there is possibility that we can write something else for this also, we will surely write it down. So this is, if we have to say the more modification, we can keep on modifying it until and unless we are okay with all the possibilities that this is the best way we can define this claim. And by writing the independent claim in the broader aspect, we can move all these specific limitations in the dependent claims, like claim number 2, 3, 4, and 5 are there. And we have specified that box like metal frame is this, power source is motor, retainer is a bowl. So, and retainer function is to receive the scrap lead. So all these extra limitations we have moved into the dependent claims. So this is the way we must have to think how we should write broader aspects in independent claim and all other specific aspects in the dependent claim. So this is what we are trying to cover, because we want scope should be broader. And why scope should be broader? These are like the exclusive rights. So these are, we can simply say, to exclude others to trespass in our own property. So what generally people do at the borders, they try to have the landmines. So these claims are simply like the landmines. The broader the coverage would be, the more the enemies or the infringer would be remain away, or if they, more the chances would be if they are just putting their feet on it. So it is, think from that perspective, the broader the scope is, the more the chances that any infringer would get caught into the scope of the patents. So infringement would be more, but it should not be that much broad. Any prior art could be there, and any patent examiner would not allow your claim that he or she examiner will simply say there is prior art available for this particular claim, so he will not allow it and it will not get patented. So anytime you are going to file a patent, you are going to draft a patent, just keep one thing in your mind: there should be a balance between scope, and scope should be narrow enough to overcome the prior art, and it should be broad enough to capture the infringers in that particular scope. So it should be a balance between these two. Any questions from anyone?
Okay, thank you so much, Mr. Rakesh. I believe we're going to have a question session from our mentees Well, thank you so much for that detail.
I just want to give another quick points.
Okay, go ahead. Carry on.
So this is suppose if you have identified some new idea. So if you are deciding not to patent your invention, you have other options. Like if you do not want to patent, somebody else might patent it. But if your invention is still you want to keep it secretive, you can keep it as a trade secret. But if once it is known to or it is available to public domain, you can't do anything. So once you are having the invention in your mind, you should try to get it patent if you want to take advantage of that in coming years, like for at least 20 years. So this is a social contract, very beautifully explained by Amosa itself. Like we are revealing our invention in the form of disclosure to government and getting exclusive rights that anybody without our permission won't be able to use it. What can and what cannot be patented is also very beautifully explained by both. So in this way, for anything, like for chair itself, we have received very good examples from Amosa. So for chair itself, like there are multiple on one particular object, you can get multiple patents. Like you can get the product patent, you can get the method patent also, like how you are producing that chair, that is also a method for patenting the production of chair, and the end product is the apparatus that we can get it patented. And whenever we are doing some kind of modifications in the chair, maybe it is on the back side or the armrest or the wheels, we can get patents on further modifications also. Now coming to the drafting part, I had also already given you a very fine example. So there are 4 critical stages. One is the invention disclosure. The second is the patentable or not. We have to just quickly get an idea whether it is falling into these restricted categories or not. Third is the drafting. Fourth is prosecution. And for drafting, we have to write down in such a manner the claims that this should overcome the prior art. The scope should be narrow as well as the broad. So this is we had discussed. Coming to this one, problem statement part. So you must have start with the previous problems itself. Like she has given the example of the chair itself. So the earlier chair was only having the 4 legs, but the rocker was not there. So that was the problem, and then we are identifying the technical and economical benefits from by solving that particular problem. So this is how we should start with patents. Accordingly, if the problem is defined, there is very good saying that if we are defining the problem in a fine way, then we are able to reach the half of the solution. So in the same way, problem is defined very clearly, we would be able to define the solution very beautifully, and the solution is nothing but the novel and inventive aspects of your idea, and for the same you can get the patent and you can write the same solution in the claims itself. This is one example, like for pouring the tea, a pouring vessel with 2 spouts. Earlier it was only this, so this was the problem, like a teapot with 1 spout. So it is having the problem of taking more time in pouring the cups, in filling the cups. This is a prior art where it is having 2 distributors for quickly distributing the fertilizers. And it is again another prior art which is having 2 different nozzles for filling up the teacups. But these 3 are still the prior arts because this is only having 1, so one cannot get the motivation to come up with this one. It is from different field. And this third one is, if it is having 2 spouts, it is taking twice of the time for filling up the cups. But here, by having these 2, you are simultaneously, you are able to, or user is simultaneously able to fill the cups in the same amount of time. So this is your unique concept. This is what we discussed, how we can simply define our invention, the problem, then the difference from the prior art, and what are the advantages of your invention over the prior art. This is about identifying the novel features from, and we can simply say the problem statement or problem solution approach, that we must have to identify the problem we are about to solve with our invention, and then the what are the technical solutions and technical advantages. And if these three things are clear and we had noted it down, now the thing comes to next part is the drafting. And while writing, these are jargons which we needed, just like I had given you an example. For electric motor, we can simply write the power source. For bowl, we can simply write a retainer. For other things, like if we are using some kind of spring, rather than writing spring, we have to write it down energy storing means, because it is a much broader term. For writing a toy ball, we can simply write down a spherical object with floppy filaments. A ball bearing is very narrow term. We can simply write it plurality of balls. And for writing, suppose a nail, screw, or rivet, we can simply say all these are fastening means. So whenever you are writing, just write down first set of claims with the narrow or straightforward language, and then keep on updating it with the patent jargons, or we simply say it a broader terms. Then only you will be able to get the broader scope. Suppose if I am simply saying apple or banana, so these are the types of, but if in other aspect I am simply saying fruits. So fruits is a much broader category. We simply say that genus or species in this particular example. But now only if I am specifying a cell phone, so it is a broader category. But if I am saying the Android phone, so it is a very unique category, and I am excluding from the iOS and Windows phone. So in that way only, you must have to choose a selection of words should be you must select the words very carefully, and accordingly your scope will get defined. So this is all from my side for today's session. If you have any questions to ask, feel free to ask.
Thank you so much, Mr. Rakesh. Thank you so much. Okay, before we take the questions from our mentees, I think we should just quickly do a picture time. This is in GT program is where we take pictures of the session, showing the mentees, the mentors, and the fact that here at JIIPCC, we have a good time while getting knowledge. So I want to employ all our mentees. Our mentors already have the cameras on. Please, if you're on the call, or kindly turn on your camera, please, for us to have our picture time, as Mr. Williams would quickly handle that. Thank you. I know it's pretty dark in some places. If you have some light, it's still fine. We just turn on our cameras and let's have a picture time. Thank you very much. Mr. Williams, please, when you have the shot, let me know. Thank you. You can do what to smile too, it helps. Who knows, my patent your smile.
I've taken the picture. You can go ahead.
Okay, thank you so much. Thank you. Please hold your copyright very well in that picture.
God's will, do we have ladies in this class at all?
I don't know. I think there should be, from the names I saw on the slide, I believe we should have some ladies here. By the next class, we'll be dragging them through. Trust me.
Let's see the ladies in the class, please. Raise up your hand. Let me see you.
Please, where are ladies? Okay, I think they're not here at the moment. Well, I'm sure by the next class we'll have them complete. Maybe network or something.
A few mentees will not have ladies who are
Oh, Precious.
Okay, we have Precious.
Please. Yes.
Which of the precious, please? Let me see your face. I don't know why the ladies are keeping quiet. It's International Women's Month, too. Why are you guys keeping quiet? Don't let the guys sideline you.
Exactly.
Show your face. Let's see you.
Hello,
I even had a
Precious.
lady present. We're talking about inclusion, and you guys are staying there. Yeah. Anyway, if you're interested in patents, WIPO is giving a 100% free course. God's will is not for you. It's for only the females. I can see.
It is unfair.
So because that's
men
why I
want
asked if
equal
we have
rights.
ladies in this class. So if you're interested in patents, I'll advise you to take the DL301 patent drafting course on WIPO platform. Is open till 15th of March. So what it means is that you'll be able to apply for this course free of charge without paying 1 kobo. And you also get tutored and you write your exam and get a certificate between now and 15th of March for females. So you can share it in the group as well for them to benefit from that.
Thank you so much, ma'am. Thank you for this information. Trust me,
You're
I'll
welcome.
call my doctor to know it from now to 15th. If he can do something to me that can make me attend that class free of charge. Please, ladies, let's jump on this opportunity. It's amazing. Thank you so much, ma'am. Thank you to WIPO. And thank you to JIIPCC, because platforms like this, you get to hear this kind of information. Thank you. Okay, so back to you, Mr. Rakesh. I know we're almost out of time. There was something I was hoping to hear. What is the law in India saying about plant varieties when it comes to patentability? Under the laws in India, can plant varieties be patented?
Actually, I have never encountered or handled such case, honestly speaking, because my major exposure is for the US and the European countries.
Okay.
But for there also, for the plants, like for India, the maximum intellectual property law is aligned with the European patent system. So whatever is patentable in European countries, it is allowed in India also. So it is more or less similar to or aligned with that law.
Okay, thank you so much, sir. Thank you so much. Okay, now to our mentees, we have a few minutes for questions. Do you have live questions you want to ask? Trust me, if I were a mentee, I heard a lot of things I want to ask about today. My mind is still blowing up. So if you have the live questions, please signify with the raising of hand emoji, and to quickly call you to ask your questions so our mentors can handle them. We have so limited time. So I believe you have these questions. Can you throw them up now? Thank you so much.
I did a quick Google search and it shows that plant patents are not possible in India.
Oh, okay. Okay, so that means it's almost the same thing as we have in Nigeria as well. Okay, so America, you need to come and speak to them. Let's know what's happening there. Thank you so much. Thank you so much for that insight. Okay, it seems our mentees had a field day today in this session. Okay, Mr. Siyamadi, please go on with your question, sir. You will unmute yourself and ask your question. I saw you throughout the session. Great job to you, sir. I think you're still muted. Please, Mr. Madi, kindly confirm you're still muted, please. Okay, you're no longer muted.
Not audible. Not audible. Maybe earphones are not working.
Oh no. Okay, do you mind typing your question if you can quickly? Because we can't hear anything you're saying at all. Thank you. Okay, so while he's doing that, do we have any question from the other mentees or our mentors? Is there anything you want to add as a final word before we take the question and wrap up the class? Please, our mentors, any final word you think, okay, this information will be very, very nice. Okay, I think he sent in his question. Please, are we going to be availed with the documents they use for lecturing? So, Mr. Rakesh and Samosa, They're asking, your slides, would they be made available to the mentees? Fingers crossed.
Yes, I will be sharing after this session.
Okay, thank you so much. Thank you.
You can
Mr.
get
Musa,
mine too.
hooray, that's that's a good thing with gypsies. Some of these things you pay for them, and here it's coming free of charge. Thank you so much to our mentors. Thank you. Thank you so much. Please, nobody should pirate their work. Please. I trust the IP gurus that will come for you with everything. Thank you so much. Thank you. It's been a fantastic time in the patent drafting week 1 course, and we know that throughout the following weeks, we have an amazing, amazing time. Okay, I think Mr. Amadi is still typing. I believe that the beauty of patent drafting is seeing an example of patent drafting so we can understand how it works in the real world. Yes, sir. Today is just an introduction for beginners. I know as the class progresses, we will surely draft patents in this course. More secrets to drafting patents. So for real, we'll actually draft patents. And I believe as part of probably your exams or assignments, you might be given probably ideas or scenarios to work with in drafting a patent. Trust me, with the mentors we have here and what I heard them say today, you'll be patent drafting gurus in the next few weeks. Congratulations in advance. So one more time, thank you so much to our wonderful mentors. Thank you for doing a fantastic job. It was simply amazing. I think, Mr. Rakesh, I can call you the Odogu of patents right now. So that's your Nigerian name, Odogu, and then add patents. That's the boss of patents. Thank you so much for a great time. The goddess of IP herself, thank you so much, Mr. Musa, for a fantastic presentation as usual. Mr. Dennis, thank you for being with us throughout the session. To our amazing mentees, thank you for a great time. I hope by the next time we have this class, we'll have you in your numbers. Once again, thank you to JIIPCC for this opportunity. Until the next time we have more insights into the world of patent drafting. My name is Goslav Kamaloni. I was your moderator for today. Have a fantastic night. Good night.
Thank you everyone.
Thank you.